You're welcome to MBR training. This session of MBR training with the CEO of Modesty Real Estate. This training is brought to you by Modesty Billionaire Realtors, where we train people to become realtors from the scratch and we give them the opportunity to earn from the comfort of their home. So if you're looking at earning hundreds and millions of naira from real estate without quitting your job, you can call the number on this particular flyer to join Modesty Billionaire Realtors and get accurate knowledge about real estate and get properties that you can sell within and outside Nigeria and make money from the comfort of your home. Also, if you would like to learn more about real estate, you can always enroll for a real estate edge class. So call the number on this flyer for more inquiry and see how you can enroll and become a certified realtor by enrolling for our real estate edge class. Welcome on board to this training on understanding land documents.
So every investor must know. We cannot overemphasize the place of land title in real estate. We cannot overemphasize the place of a title document in real estate. So we are going to start by please mute your mic if you are live while I'm talking. Okay, so we are going, as I was saying, you cannot overemphasize the place of land document or title document in real estate. Okay, so and of course, as we continue this training, if you need to respond, you can always type. There's a chat area on the app we're using. You can always type. Then when it's necessary, you can unmute your mic and talk. So I would like us to be very fast. I'll be talking for the next 40 to 45 minutes, sharing major things that you need to know about a title document, either as an investor or a realtor. Okay, so first of all, what is it? When you hear the word title document, what is a title document? What is a title document? So let's start by answering what a title document is. A title document, simply put, is a document that transfers ownership or confers ownership from one person to another. It is a document that transfers ownership from one person to another. All right, so when you hear title document, what should come to your mind is ownership. It is a proof of ownership. It is a document that transfers ownership from one person to another. By so doing, it shows who owns a particular land or a landed property. All right, the title of a land is the status of the land, who owns the land, why the document itself that describes the status is the title document. All right, so it's very, very important to understand what a title document is. For instance, as a realtor, why should you know what title document or what a title document is? Let me share this story shortly. I remember sometime last year I posted somewhere that a survey plan is not a title document. A surveyor attacks the post and say, no, how can you say a survey plan is not a title document? This. A survey plan is very, very important. I just laughed and I now asked the surveyor, what is a title document? And the person couldn't answer. Before, I didn't say a survey is not important. That's why you should stay to the end of this training, because all of those things will be explained and trashed, right? So it's very, very important, but that's not a title document because it doesn't transfer ownership from one person to another. So you see why knowledge is important. Imagine buying a property that has only a survey plan as the document backing it up. You may be buying trouble because you do not know. So a title document has to transfer ownership. It has to transfer ownership from one person to another. So why do you need the knowledge of land titles? Why do you need the knowledge of land titles? Why? That's the question. First of all, as a realtor, you need that knowledge because it helps you to build confidence. It helps you to build confidence. You are able to educate your clients. You are able to build confidence in talking to your clients. Imagine a realtor that does not know what a probate is, what a will is, what an assent is, how to identify an assent, how to identify letter of administration. All of those documents, a court order, what makes a court order valid? So all of those things, you need it because you can be thrown off balance when dealing with certain properties or selling clients. So it builds confidence it helps you to actually know exactly what you're doing, and it helps client to trust you more. It helps client to trust you more. People want to buy from someone that they believe knows what he or she is doing. So it's very, very important. And most important, as a realtor, understanding of land titles or title documents helps to protect your client's money. Very, very, very important. If you help a client to secure a property with the wrong title, by the time the client is losing money, you will be involved also. Definitely you will go in for it because the client bought the property through you. So you have to understand that it helps you to protect your client's money. It helps you to protect your client's money. So your knowledge of title document helps you. It also helps you to avoid or win some legal battles. Avoid or win. Why am I using the word win? Because sometimes it is 100% unavoidable because land intruders can come from anywhere. All right, so let me know if you are following. Hope you can hear me. I've given like very importance of this knowledge for realtors. Can you hear me, everyone?
Yes, sir.
Okay, let me know if you can hear me. Okay, all right, good. Now, as I was saying earlier, it helps you to protect or win legal battles as a rector, knowledge of title documents. Now, court is not necessarily a court of justice, but a court of evidence.
Yes, sir, we can hear you, sir.
Okay, good. A court is not a court of justice, but a court of evidence. You can be noting many of these things even in the group.
Yes,
All
sir.
right.
Yes, sir.
So you can note it in the group, note it in the platform you belong to. Okay, good.
Yes, sir.
So, as I was saying, a court is not a court of justice necessarily, but a court of evidence, meaning that with the right titles, you are able to defend yourself when there are land intruders. A title document serves as a major evidence to protect your property. So it is not a matter of who truly owns the land. It's not a matter of only God knows who is saying the truth. It's a matter of what evidence do you have on grounds to provide before the court. What evidence do you have on ground to provide before the court? So remember, I say it's not necessarily a court of justice, but a court of evidence. So your knowledge of title document is going to help you protect your client's money as a realtor. Then, as an investor, of course, it will help you protect your investment, your land and your investment. As an investor, the knowledge of a title document will help you protect your land and your investment. All right, it will protect your land from land grabbers. It will protect your land from people that are intruders, from that may rise up tomorrow to claim your land. So title document is very, very important, both as a realtor and as an investor. And of course, it will also increase the value of your land. When you have a landed property that has the right title, it helps you to increase the value of your land. So as whether as a realtor or as an investor, you must understand that a title document is very, very important. Saying earlier, the knowledge of a title document helps you to protect your assets, protect your investment. In fact, in summary, as a form of introduction, there is no document, no land. No document, no land. No title document, no land. That means that the title document is as important as the land itself. The title document is as important as the land itself. Is as important as the land itself. So if you don't have the right title for your property, definitely you don't have a land. If you don't have the right title, you don't have a land. Okay, so it is, remember I said it is not necessarily a court of justice, but it is a court of evidence. So your title document is a major evidence of ownership. All right, it is a major evidence of ownership. So you cannot say you own a land when you don't have the title to back it up. You cannot say you own a land when you don't have a title to back it up. Hope you are following. Let me see if you're following me.
Yes, sir. Yes, sir. Yes, sir.
All right. Oh, good. Now, so let's look at some examples of a title document. All right, some examples of a title document or some types of title documents. The most common, most times, a title document is a deed. A deed is a title document. A deed is a title document. All right. Now that can be a deed of assignment, a deed of transfer, a deed of gift, a deed of a deed of gift, a deed of assignment, a deed of transfer. Now, deed of gift most times is applied when somebody gives you a land. If your friend, for instance, your brother, your mother, your father, anybody gives you a land, you must ensure you have a deed of gift as a legal document that is backing up the ownership. Don't just say, people know now he gave me the land. Remember, this land is going to outlive you. This land is going to even outlive your children if you don't transfer it to somebody else. So you can tell the person that you want to prepare a deed of gift for him to sign. That will now serve as a title document or as a legal backing for your land. So a deed is a title document. It's only many times a deed of lease or sublease that don't necessarily serve as a title document, especially in some contexts. I'm going to explain that as we continue. But these generally are title document, and for them to actually serve as legal document, a deed ought to be, that is the spelling of a deed, deed, yes, or a deed ought to be registered. A deed is not yet it does not mean it's not valid. Of course, it's valid as an equitable document. It's valid as an equitable document, but it's not a legal document. It is registered. So when a deed is prepared, it is expected to go register the deed in the Ministry of Lands for it to be actually a legal document. So you are expected to register a deed. You are expected to register a deed. So a deed is a title document because it transfers ownership. It confers ownership from one person to another. It confers ownership from one person to another. Hope you are following. It's a legal document. You can transfer ownership from one person to another. Now, in preparing a deed or in your client getting a deed, you must ensure that the deed has what is called a reciter. In law, there is what is called a reciter. Something happened sometime last month, last 2 months. A friend of mine wanted to buy a property. So as I was saying, a deed must have a reciter. It must have a reciter. What is a reciter? It is the part of the deed that shows the history of the land. For instance, if Mr. A is transferring the land to Mr. B, after the major description, this is a deed of transferring this particular property from Mr. A residing in so place to Mr. B residing in another place. Then the next thing is to show the reciter or the background of the land, how Mr. A acquired the land. All right, I was sharing a story earlier on how a friend of mine wanted to buy a property, and funny enough, this is not to disregard any lawyer or anybody. No, a lawyer prepared a deed and there was no reciter. I had to tell her that no, this deed is not valid. If there is an issue on this land, this deed cannot actually fly. You may lose the land even if you are the owner, because in the deed there was no reciter. There was no place that stated how the person selling the land to her acquired it. So you must understand this. So that is part of the transfer of ownership. So Mr. A is selling to Mr. B. Then part of the deed must contain how Mr. A got the land. Is it by inheritance? Is it that he bought it from another person? Let's say Mr. C or Mr. D. So there must be a reciter stating the background of the property. All right. This is part of what makes it an authority or a proof of ownership. If not, if you have an issue on the lands tomorrow, you can actually lose the land. If you provide the deed without a reciter, and the person that is trying to grab the land with you provide a deed with a reciter and enough evidence, funny enough, the court may grant the land to the other person with a reciter that is able to show the background of the person selling to him. So remember, it is not necessarily a court of justice, but a court of evidence. All right, so a deed must have a reciter. It must show the history of the land. That is the reciter. It must show details of the buyer, the seller, if it is a buy and selling contest, or if it's a deed of gift, it must show details of the person giving and the person receiving, and details of the property. So a major example of a title document is a deed. So never get a property without a deed. Or if you have a property right now, there is no deed to back it up, find a way to get a deed. whether you inherited it, whether it was gifted to you, whether you got it by will. I'm going to explain all of that. So ensure you get a deed and register the deed in Ministry of Land, because that is what will make it legal. That will be what will make it valid at all costs. All right. Another example of a title document is a court order, and I need to explain this. A court order. Now in Nigeria we have different court, customary court and the like. The highest what's the highest court in Nigeria? Let me ask us. The Supreme Court is the highest court in Nigeria. That means a court order can serve as a title document, especially if it is from the Supreme Court. Now, if you have a court order that is not from the Supreme Court, let's say a customary court or just any court that is not the Supreme Court, if that is the proof of ownership that the person has for the land, what if the person that is having the dispute with or a relation of him appeals to a higher court after 5-15 years? You know, he can appeal to a higher court, say the Supreme Court, with enough evidence. He can still win the land. And if you are the one that bought the land, you will still lose your land, no matter how you bought it. So you see that before a court order can serve as a title document, it has to be from the Supreme Court, it has to be from the highest court, it has to be from the highest court of authority. So that can serve as a title document. Another thing that can serve as a title document is a certificate of occupancy. And please pay attention very well. You know, we made a video recently where I was explaining that you can still be scammed buying a land that has a C of O, and this I want to explain that clearly. Now, what is a certificate of occupancy? It's simply a land that states that the government has leased out a particular portion of land to you for a period of 99 years. If it's in Nigeria, all lands belong to the government according to Land Use Act of 1978. All lands belong to the government, especially under the control and influence of the governor of the state. So the governor can actually lease out the land for 99 years and gives you a certificate of occupancy, C of O. Now there are two types of C of O. Pay attention. There is the allocated C of O and the applied C of O. There is the allocated C of O and the applied C of O. The applied C of O is when I have a land, I bought it, for instance, I'm Mr. B. I bought the land from Mr. A. I did my registered survey. I did everything I ought to do. Then I now applied to Ministry of Land that I want a certificate of occupancy. Though they grant me that certificate of occupancy, they give me the C of O document. That is applied C of O. Now there is the allocated C of O. The allocated C of O is where it is the government that allocated that particular land to you directly. Like some jewelry, some places, for instance in Ibadan, that the government allocates it directly. So they just give you a certificate of occupancy that is an allocated C of O. Now, if it is an applied C of O, first of all, before I explain what I want to explain, hope we got the difference between an applied C of O and an allocated C of O. Did you get the difference? So now listen to what I want to say next. If it's an applied C of O, you can still lose your money buying a property with an applied C of O in some contexts. I'll explain. Because when an individual applies for a certificate of occupancy to the government and he provides all the necessary proof and evidence, especially a registered survey plan, a deed, major things to show that he bought the land or the land belongs to him, the government grants him that certificate of occupancy. And many times it's not really because the government has done any due diligence to prove that the land belongs to him. So it may be that he's not the actual owner of that land. He just applied for the C of O. He grabbed it from somebody and he applied for the C of O. He did all the documents and government granted him that land. Then he now want to sell it to you and he's shouting, land has C of O, land has C of O, land has C of O. Then you didn't bother asking for other documents, the deed of transfer, the proof of ownership, or doing your due diligence to show how he acquired the land. Did he inherit it? Was it by custom? Or one of these training we're going to teach you how the different ways an individual can own a land in Nigeria legally. All right, was it by acquisition, by custom? Was it by inheritance? Was it by will and assent? How did he? So if you buy such a land and the person got the C of O, but he's not the actual owner, if the actual owner arises after 20 years, I'm using the right year, after 20 years, and prove to the court with enough evidence that he's the actual owner, the C of O is going to be revoked, then you're going to lose your land. So, for the applied C of O, if you're buying a property with an applied C of O, ensure you do your due diligence. Ensure that you have other proof, other evidence. So don't just say land has C of O is genuine, land has C of O is genuine. It's only people that are ignorant that you can say that to. It is not enough evidence, especially if it is not an allocated C of O. If it's allocated C of O, directly from the government allocated that to the person. But if it is an applied C of O, knowing fully well that you don't necessarily, you ought to be the owner before you can apply for the C of O. But in some context, you may not be the rightful owner in applying for the C of O. It may even be that you are ignorant because the person you bought it from a wrong hand. So innocently you apply for the C of O. Now you are selling it to another person. So, if you're getting a property or your client, if you're a realtor or an investor, as a realtor, your client is getting a property with a certificate of occupancy, you must make sure there are other things to serve as evidence to show that the property actually belongs to him, right? Am I making sense? Are you following? So you must make sure that the person actually has the rights to sell the property. You must make sure that there are other documents to back up the transfer of ownership for the person. So a C of O is a title document with all of these contents put in place, especially if it is an applied C of O, not an allocated C of O. Another example of a title document is what can serve as a good title. Are you following? I say a court order, a deed, then a certificate of occupancy. And we're going to pause there for a while. Let me explain what cannot serve as a good title. What may not serve as a good title. This is what you should pay attention to. What may not serve as a good title. Now, there are some documents that don't necessarily or cannot on their own serve only as a title document of a land. Number one is a survey plan. A survey plan cannot on its own serve as a title document. How many of you have seen a survey before? You've seen a land survey before? Can you hear me? You've seen a land survey or a survey plan before?
Yes, sir.
Yes, sir. Yes, sir.
Yes, sir.
Okay. Now, if you notice that, let me give an instance. When you answer, please mute your mic. Okay. Now, if you notice that it's... Hello, mute your mic after answering. Mute your mic. Mute your mic. So as we were saying before, we're explaining the things that cannot necessarily make a title document. Having seen what a title document is, if you have seen a survey plan before, you notice that a survey plan is not necessarily a title document because it does not have a reciter. It does not necessarily show the evidence, the history of the land. It does not show who the person got the land from. It does not show the signatories of the owners, both the seller and the buyer, or the transferee and the transferor. It does not show any of that, but it has its own uses. What is the essence of a survey plan? It shows the boundary of the land. It shows the boundaries of the land. It shows the size of the land. Then it shows the location of the land. Those are the three key things that the survey plan shows. So a survey plan on its own is a very good document that you should have, and it has to be registered in the Ministry of Land, in the Survey General's office. So a survey plan on its own is a very, very good document, but it is not a title document because it does not have a reciter. I already explained what a reciter is, right? It does not have a reciter. It does not show the history of the property. It does not give place for both the transferee and the transferor to sign, so it cannot serve as a title document. It does not confer or transfer ownership, but it shows the boundary, the size, and the location. Hence, it is very, very useful when it comes to land search. When it comes to checking whether a property is under acquisition, a survey plan is very, very useful. When it comes to checking whether a property belongs to a person or not, a survey plan cannot be the only title you are using because it's not a title document. Hope you are following. There has to be an additional title. There has to be a deed. There has to be something else to prove that this property belongs to the person, not just a survey plan or a registered survey. All right? Because a registered survey does not show It does not confer ownership. It is not a title document. It's a land document, but it's not a title document. Remember, those of you that have started from the beginning would define what a title document is. So how does it apply to a realtor or an investor? It means that if you're buying a property and the seller or the person conferring the property to you has only a registered survey as a proof of ownership, you have to be careful. You may be buying a property that is not genuine, because anybody can get a registered survey. Anybody can actually get a registered survey. It does not show where the land is coming from. It does not show the proof of ownership. It does not show anything except the size, the location, and the boundaries of the land. So if the court case arises tomorrow and you have a land that genuinely belongs to you, then an intruder comes and say the land belongs to him, and the intruder brings the registered survey. The intruder brings also a deed, brings every other evidence, while you only have a registered survey. Unfortunately, you may be the owner, but you may not be able to win the case, because a registered survey does not serve as a title document. Remember, as I said when I started, it is not necessarily a court of justice, but a court of evidence. When it comes to land matters and land dispute, it is a court of evidence. So you must have ample evidence as a proof of ownership for your property. Not because you are scared whether land is genuine or not, but because an intruder can come tomorrow either against you or even for your children, when your children inherit the land, or the next person you want to sell or transfer it to. So you must be very, very careful. So a survey plan in this context, a survey plan actually cannot, or is not a title document, but it's a land document. Let me see if you followed the explanation. All right? Are you following?
Yes, sir.
So,
Yes, sir.
okay, good. So if you have questions, you can take note. We're going to take questions at the end of the training. Just take note of your question. So we said some documents that cannot serve as a title document. We say a survey plan. Then another is a power of attorney. A power of attorney cannot necessarily serve as a title document, especially, of course, I understand there are some places in Nigeria where there is an exception for power of attorney, like in the East. There are some places in Nigeria that there is an exception, and I'm going to explain that exception briefly. Now, what's the power of attorney? It's a legal document that authorizes a person to carry out a particular task. He can authorize you to sell a property for the owner. He can authorize you to manage a property. He can authorize you to carry out a particular task. He can authorize you to sign on behalf of the owner of the property. But that itself is not the title document. It is not enough evidence to show that the land belongs to the person that owns the power of attorney. So there must be other evidence. There must be a deed, there must be a CFO, there must be other land documents to show proof of ownership. So a power of attorney on its own is not necessarily a title document. In a case where it becomes a title document, in some places in Nigeria, it has to be backed up with a deed. It has to be backed up with a deed. Yes, it has to be. It has to be backed up with a deed. If not, it is not a title document. So those are some major documents that you should take note of that are not title documents. I said the next one we want to look at is an applied CFO. An applied CFO. I already explained the difference between an allocated CFO and an applied CFO. There are some cases that an applied CFO cannot be the only, cannot serve judiciously as a title document, because anybody can apply for CFO and get it, yet he's not the rightful owner of that property. As long as he has evidence to provide to the Ministry of Land, he has the registered survey to provide, he has the he's able to cook up a deed or cook up something to apply, he will definitely get his CFO. So long and short of it all, as a realtor, as an investor, if you want to get a land, you must pay attention to all of these documents. Imagine getting a land and the only thing that you have is a survey plan. You need to be careful. Then the next document that is not necessarily a title document. Remember, we have looked at examples of title document. So we're looking at other documents that are not title document. Is a lease, a deed of lease. A deed of lease is not necessarily a title document. Please pay attention. It's not necessarily a title document. What is a lease? Well, what is leasehold? It's simply an agreement between the owner of a property and the occupant for a particular time, especially from 30 years above. If you have a property and you to rent it out from 3 years above, then you are on a leasehold. You are leasing the property, not necessarily tenancy. So the difference between tenancy and leasehold is just the number of years. Anything from 30 years above is what makes a lease. Now, if there is a deed of lease, let me give an instance. Mr. A has a property. That Mr. A now leases it to Mr. B, and they get a document called a deed of lease showing that it has leased this property for say 5 years, 10 years. Mr. B cannot sell or transfer the ownership of the property to Mr. C with that deed of lease as the title document, because the lease is only conferring ownership for a specific period of time. Now we understand some cases where government issues some document in some GRA, say Ibadan or some places, and they call it a lease or a deed of lease. Of course, that in its own is not, you cannot call it, they can call the document a lease, but that in its own, as lease should be, is not a lease, because it's supposed to be an allocation later where you're having a direct allocation from the government. So we have some context, some exception where a lease can serve as a title document, but not that somebody leases a property from someone and the person is then transferring ownership to another person with that lease. Let me see if you are following. Can you hear me? So all right. So the long and short of this training is to enlighten you what a title document is and what makes a good title, and what you should be careful of, what you should watch out for in a real estate transaction, either as an investor or as a realtor. So I believe with this short training, you've been able to gain little insight or much insight about title document. And remember, you need to tread carefully when it comes to land and land documents. So I'm going to take our questions briefly, then we'll end this training. So let me take one or two questions. Okay, of course, I mentioned a will and an assent. Let me quickly explain that. I can't explain probate and letter of administration. That's It's well covered for in another course. But let me just explain what an assent and a will is. Everybody knows what a will is, right? In the sense that somebody owns properties, and before he dies, he prepares a will that assigning who and who should inherit a particular property. Can you hear me? So that's a will. It is a It's the document that contains or describes the ownership of property for a deceased person. All right, is always describe how their land or their landed property should be distributed or transferred after their death. The deceased person in most cases is actually called the testator. The deceased person is the testator, while the person to inherit the property is called the beneficiary or the heirs. All right, the testator, the beneficiaries, and the heirs. Now, a will on its own cannot serve as a title document without an assent. Please pay attention. A will on its own cannot serve as a title document without an assent, because in a will, there is what is called executioners. The executioners are those that are to make sure that the will stands after the person has died. Let me give an instance. Imagine Mr. A owns several properties. Then Mr. A has B, C, D as uncles, relatives, and he has children 1, 2, 3, 4. So he now in his will describe that this property should belong to number 1, number 2, number 3, number 4. He will now appoint BCD as executors of that will. That means that they make sure that the will comes to pass. They make sure that the will is carried through to the end with the help of his lawyer, right? Now, where an assent comes in is this: if the testator dies and you are inheriting a property from your father, from someone that in the will stated that the property belongs to you, you have to request for an assent to be prepared. It is a legal document prepared by lawyers, a deed or something, an assent that will be signed by all the executors of the will. All the people that the person said they should witness that will, another name for executors, witness the will, they have to sign it, showing that this property truly belongs to you. How does it apply to a realtor? If you're selling a property and everybody is shouting, "He has the will, he has the will, he has the will," always request for an assent. Always request for an assent. Always request for an assent. It's very, very important. Always request that there be a legal document that is prepared, signed by all the executors that are stated in the will, proving the ownership of that particular property from the testator. Let me know if this is clear. I'm trying to be as simple as possible and not using too many technical terms. So did you understand the whole concept of a will and assent, right?
Yes, sir.
Okay, so if you are buying a property that has a will, make sure you have an assent. In that case, without that, it cannot necessarily serve as a title document on its own without an assent. Because if you do that, you can actually lose your money or lose the money of your client buying such property. Remember, no land, no title document, no land. It is not necessarily a court of justice, but a court of evidence. So you must have the right evidence to show that the property belongs to you. Okay, so let me take one or two questions briefly as we begin to round up this course. That's very, very important question. The question says, if you're buying a property that the owners of the land don't have any documents to prove that it belongs to them, what should you request for? I remember I mentioned in the course of this training that there are different ways to become a landowner in Nigeria legally. There are different ways. There is customary ownership. There is a land can belongs to a community where the community leader is the one executing the land or the transfer. You don't necessarily need a document, but what you do is in preparing your deed, make sure all the key persons in the family sign the document. If you are buying it from a family or from a community, make sure all the key persons sign. Make sure every key person, the key persons in the family or in the community sign. So that's actually basically what you need. It's not they may not have any title document to prove. It may be by reason of custom. And I told you that there are different ways to own a land. So there is customary ownership. All right, there's customary ownership, and that's in a way is recognized in Nigeria. So you are just the one that will then regularize your title after buying it. Hope you get that.
Yes, sir.
Okay, so let me take other questions.
Okay, sir. Thank you so much for the details. I really learned a lot. Thank you so much, sir.
You're welcome.
Sir, my question is, is there a way you can recognize all these, like, all these, all these examples of these documents? Probably when you see them, does it have the agent that states their name, or is there a way you can recognize them when you see them, sir?
Not when you see a deed, it will have a deed now. For instance, okay, there way you can recognize titles. When you see a deed, you will have deed of transfer, deed of assignment, deed of this. Well, a certificate of occupancy, if you have the name as certificate of occupancy. So in most cases, the documents we have contain their names. So it's a major way to recognize them. So, and most of them can actually be vetted in Ministry of Land. If it's a deed that is already registered, remember I told you, if you have a deed, ensure that it is registered with Ministry of Land. If it's already registered, you can vet it, you can confirm it from Ministry of Land. So aside the name that is written there, okay. So if it's a certificate of occupancy, of course, you can confirm that too. So for many of the title documents, it's what you can confirm either from the name or from the Ministry of Land, okay. All right, so let me take other questions. Okay, so in the absence of any other question, let me say this. Now, crowded with many persons that are not enlightened about real estate. Just like the example I shared, how I mentioned that a survey plan is not a title document, and a surveyor was attacking me that it's not true, it's not true, it's not true, you don't know what they're saying. And I asked him what is a title document. He couldn't answer because he thought I say a survey plan is not a land document. I did say so. I say a survey plan is not a title document. So knowledge will always set you apart and will help you to safeguard your client's money and investment. So I'm going to encourage us to go for knowledge. And at Modesty Real Estate, we have a detailed course. Apart from the fact that we have a group where we give you the opportunity to market our properties and earn commissions, massive commission, what is called Modesty Billionaire Realtors, MBR. you repost the properties, you get your commission on lands and buildings. It is also very important that you learn and keep learning. So we have a detailed course for realtors. The course has two aspects. The course has the aspect of the legal aspect and the marketing aspect. In the legal aspect, we covered everything about you need to know about law, Nigerian real estate laws. All right, how to become a landowner, probate administration, data of administration, many of those things that I explained here, and many more that I didn't explain. And in the marketing aspect, we showed practical way to sell real estate. I shared many of my secrets on even on how I sold 22 plots of an estate within a month. Of course, I may not be the expert yet because we are pushing, but I have quite a number of results in real estate industry as a top selling realtor. So I shared many of the marketing tips that you will learn and the legal part of real estate. So the admin is going to communicate that more in the WhatsApp group for realtors. But the course is only for now selling for 50,000 naira instead of 100,000. There is a 50% discount that is available on the course. So if you're interested, which you should be, you do where to get the course between now till August ending. After August ending, it will return to the actual value, which is 100,000. All right, so it's just for a 50,000 naira course, and it's certified. It's a certified course. You're going to learn everything about real estate, both in the marketing, in the legal part, about land documents, about how to become a landowner, many things. And of course, you have the privilege of having direct access to me in the sense of asking questions and mentorship in your real estate industry. So if you're ready for that, you can always send a message to the admins to register in the real estate edge class. The essence of the class is to raise smart realtors with results. Is to raise excellent realtors, smart realtors with results. Realtors that are smart in the sense of knowledgeable, and they have results. They don't just have knowledge, yet they don't know how to sell. So that is the essence of the course. So I'm going to hand over to the admin now to round off and continue the training while I stay muted. Okay.